Scott Oswald here. I'm the chair of the Qui Tam section of the Federal Bar, and we are going to be having our annual conference this year on February 28th and March 1st, 2019. We are privileged to have today Andrew Miller, who is a shareholder at Barron & Budd here in Washington. And Andrew, your panel that you have for the annual conference this year on ability to pay. It's kind of a sense of what folks can expect if they, when they attend that panel.
Sure, happy to, and thanks for having me. Ability to pay, I guess as it's known in the industry, is probably better referred to as inability to pay, meaning that ultimately when a defendant is found to have liability under the False Claims Act and the government has assigned a monetary value to those damages, the defendant doesn't have the financial wherewithal to actually pay that bill as demanded. So what's interesting about this is, this is something that comes up in a lot of cases, and we're seeing it more and more. And I think even if you've had experience in your practice with these issues, I think the dynamic panel that we've put together of federal prosecutors, financial analysts within DOJ, as well as the perspective from the Qui Tam bar and the defense bar, I think you're going to learn something new. And if you've never had to deal with it and you've only heard about it in passing, this is an opportunity to get a full education about what the issues are.
So it sounds, based on what you're saying, we're going to actually get a sense of what the government considers when a defendant comes forward and says, look, I don't have the ability to pay. Is that right?
That is right. That is right. And so we're very privileged to have Eileen Zimmer, who works as a senior financial analyst at DOJ, who her and her team come in and they do this analysis if and when that issue ever arises in the case.
Give me some sense of, you said this is happening more and more. Why do you think that is?
I don't know if I have an answer to that, but I think it's important for attorneys on both sides to really understand what the issues are so that they can navigate their clients through the process. And I think also, DOJ is getting better and better at this analysis as well. And I think altogether the parties can, better understand the issues and better represent their clients, in these circumstances.
When one of these issues comes up with you, and you mostly represent relators in these kind of matters, what's that conversation like with your client when there's maybe an amount being discussed as a resolution, and then this issue of ability to pay comes up? What's that like?
It's dispiriting, I'll say that. Typically our clients have come forward with inside information, and they believe what they've observed to be fraud has occurred, and when they get validation that is in fact what has happened, but that then the defendant isn't able to pay what the government thinks that they owe, there's a level of frustration that is shared by their counsel as well, but that's just the reality of the situation. So what we do is we guide our clients through the process, and ultimately whatever the settlement amount is, it has to be fair, adequate, and reasonable, and the False Claims Act provides for that assurance. And so, whether we hire our own financial experts to analyze the financial information provided by the defendants to the government, or other means, we have to go through the process to ensure our clients that the amount that's being offered is in fact fair, adequate, and reasonable.
Got it. And my guess is probably for defense counsel, it's equally difficult to have that conversation. When you talk to defense counsel about, what they go through in those situations, give us a sense of what that conversation is like with their clients.
Sure. And sometimes we're aware that some counsel and some defendants look at the ability to pay issue as a discount program, which it is in fact not. It's not just an ability not to pay less than what you owe. It actually is a very thorough process where you have to open up your financial books to DOJ and to have a full accounting of your distress situation, if that exists. And so and what's interesting about also from the defense perspective is once you get into the ability to pay analysis, you basically are no longer having discussions about liability. Liability has been established, so there is no further negotiation on that point. So it's purely a financial, calculation.
So really about how much the defendant is going to pay, not whether they're going to pay.
Correct.
Got it. how often does it come up in situations where there might be some sort of criminal aspect as well? I know that there's some differentiation the Department of Justice makes in terms of what is available to relators share. Is that ever a factor at all in these kind of cases?
It's my understanding that DOJ keeps those things separate, but I think that it's a great question, and I'm glad that we have two folks from the Department of Justice who will be on the panel, and it will be interesting to see how, when you've got those parallel investigations and potential liability both on the civil and criminal side, how an ability to pay calculus plays out.
So maybe tell us a little about you personally. When you're not lawyering at Barron and Budd, where do you spend your time?
When I'm not working, I spend most of my time chasing around my two very young daughters. My wife and I really enjoy. The girls are only 5 and 2, and so we jump in with both feet, chase them around all their activities. I've never known so much about ballet and gymnastics, and they're becoming little fish in the swimming pool as well. So anything that we can do to help them out, and in all their areas of interest, which is officially everything under the sun right now. So,
Andrew, thank you.
Thank you, Scott.
You're welcome. And we look forward to seeing everybody on February 28th and March 1st, 2019. You can sign up at the Federal Bar website at www.fedbar.org.